is Teresa, and we are starting this evening with our youth justice session. So let me give you a little bit of intro about Be the Change. So Be the Change offers virtual information and knowledge transfer services to families in Peel and Simcoe regions. Our current programs include Parent Connections, which is funded through Trillium, and Black Girls Rock, which is partially funded through Electra and Bear Community Foundation. The topic being covered this evening is youth criminal justice processes and youth records. So the reason for covering this topic is for parents and youth to get a better understanding of the youth criminal justice processes, how it's different and sometimes similar to the adult system, types of diversions, and also give information and resources of how to access lawyers, like legal aid certificates and also legal clinics. So we are hoping that this session and the others to come will help youth and parents better understand the youth system. So please keep yourselves on mute. Questions can be asked after the presentation by putting your hand up using the icon on your screen, or just simply excuse yourself and ask your question. So joining us this evening is Emily. Emily Chan is the Community Development Lawyer at Justice for Children and Youth, JFCY, a legal clinic with specialized expertise in children's rights across a broad spectrum of legal areas. She has been with the clinic since 2003 and has appeared at all levels of tribunals and courts, participates in law reform, community initiatives, and speaking engagements to a broad range of audiences about the legal rights of children. Emily is a board member of the Canadian Coalition for the Rights of Children and the Canadian Association for the Practical Study of Law in Education. So welcome, Emily.
Thank you very much. I'm going to share my screen. I do have a slide deck. I'm not going to just read from them though, but I wanted to make this available because there's some resources here. So I thought that this way, everyone, you could share this afterwards as well for people who might want them. So that's just a cover. So the topics, as you said, we're going to about lawyers, getting lawyers, and then a youth criminal justice system. So the first bit will be on the lawyers piece. The next bit will be more on the youth criminal focus. So before I begin, because this is a recorded session and it's a group session, this is going to be about providing you with lots of legal information. I'm not able to give you legal advice through kind of a group setting. So legal advice does have to be in a one-on-one context. We will stop the recording for when we ask the Q&As, but even in that session, it's an opportunity to ask some questions about general stuff and application, and I'll let you know how you can contact our clinic about getting legal advice or other options for getting legal advice for a situation. Okay, we'll start with the lawyers. There's many different ways to get lawyers. So the two that I've listed right at the top are legal aid certificates and private bar lawyers. So private bar lawyers are just someone who works like by themselves or in a group. They might have a law firm, and you can just hire them directly. That's quite an expensive process for a lot of people and not really affordable. So then what? So Legal Aid Ontario has legal aid certificate program where people can make applications for legal aid certificates, but there are limits on it. So it is income and asset-based criteria. And as well, part of that process is they don't fund everything that exists. So you have to also fall under a category of funding that they do provide. To contact them, you just call Legal Aid Ontario, and it's a phone service to talk about whether or not your legal issue qualifies and whether or not they'll provide a certificate. There is an appeal system, which a lot of people don't know about. So, there might be a chance where you think you should be getting the certificate, but they said no anyway. So you can say, I still want to apply. I want the formal decision, and then you can appeal it. Outside of that, I didn't list it here. I'm going to add it before I send the link over to you. But Pro Bono Ontario is another organization that matches people with lawyers on very specific areas of law. So there are some restrictions in that as well. But one of the topics that comes up quite a bit with young people and families is education law, and they have a program for that. So that's really important to know. in terms of how they're paid, so going back to the legal aid system, if you do get a legal aid certificate, the lawyer has to accept the certificate, and then legal aid will pay that lawyer directly. So if you don't have a lawyer in mind, you don't know anyone, legal aid does have a list of lawyers who can accept certificates. There is a control system in that place that you have to be um, a you have to be, it's not really licensed because you're licensed through the Law Society, but you have to have an agreement with legal aid to take certificates before that can take place. The next place that a lot of people go for services is the Legal Aid Ontario funded legal clinics. There are some that are not legal aid funded. So two examples of non-legal aid funded clinics is the Barbara Schleifer Clinic for domestic violence. And then the other clinic that I know of that's not funded through legal aid is the Canadian Civil Liberties Associations. So there's different places that might not be funded. But overall, Legal Aid Ontario is quite robust. There's over 80 clinics and it covers every kind of area within Ontario. So to find your local clinic, you can go to the link that I've provided and you put in your postal code and it'll tell you what your local clinic is. Every local clinic has a different number of lawyers and the areas of law that they practice are a little bit different. So it's contacting the local clinic to try and figure out whether they can help you or whether they can refer you or connect you to who can help you. Outside of the general clinics for every area around the province, there's what we call specialty clinics, and that's what we are. So there's about 20 specialty clinics that focus on working with specific populations. So there's Aboriginal legal services, there's the HIV/AIDS clinic, Arch Disability Law, the Black Legal Action Center are different examples. And then there's one called CLEO, which is just puts out public legal information. So those are good resources to know about. So our specialty is that we work with young people under 18 mostly. So those are our clients. We represent the young person. We do have a couple of other programs that we can go up to the age of 25, and that's for young people living in shelters and that are homeless. And then we have another one for young people who don't have, who are living here by themselves and don't have immigration status. So those ones we can go up to age 25 based on the funding. The questions we get asked the most is, well, how can this young person get help? So either the young person calls or an adult can call on their behalf to make an appointment and provide some preliminary information. But like I kind of said at the beginning, like we can't really give advice through a third party or in a group setting. So it has to be a kind of a one-on-one system. So you can set up the call and stuff, but when we call back, when you get to talk to a lawyer, that will be with the young person directly. The only exception is for special education and the child is quite young and unable to communicate or really be getting legal advice from a lawyer, then we will talk to the parent in that circumstance. We are legal aid funded, so there's legal financial criteria and a bunch of other criteria on whether or not we have the space for it. Luckily, we're a fairly large clinic. We have 9 staff lawyers, which is quite large for many clinics, and so we can do quite a bit. And then sometimes we go past the 30 minutes of free summary advice and do some brief services or full legal representation. So the thing to know about for children and youth that's really important to know too is we're not the only resource that might exist. There are other places that people can go depending on what the issues and concerns are. The Office of the Children's Lawyer is the one that many have heard about. They do a lot of the family law, parental access and custody, child protection. That's the work that they do with a civils and estate side. So the only catch with that, with the OCL, is there has to be something going on in court and the judge is the one who appoints a children's lawyer for the children involved in the circumstances. The other place that exists is the Ombudsman's Child and Youth Unit. So the Ombudsman does a lot of different complaint systems, but there is a very specific one just for children and youth, and it focuses on children's aid, group homes, and school settings, as well as some concerns over the OCL if they come up. That's less common. So I just wanted to make sure that you were aware of those as well. This is what our website looks like. And everything that we're going to talk about today, there's a lot of content on our website, as well as so you can download it under the Your Legal Rights section. It opens and closes, and you can read legal rights information. And then the other section on the right are resources. You can download it in a publication format. If you want to have it as a document, it's in PDFs, or you can also print it off. And so that's something that a lot of people do, especially for a young person who might want some information and they want to take it away with them. What we do is lots of areas of law. These are our calls from 2023, and that's just how we logged it. So sometimes it's not a perfect science for us. So sometimes some categories overlap, and so we just have to pick one to put them in. But these were the number of calls. These are kind of the areas of law that have come up. So youth criminal justice is a big one. We're going to talk more about that. Education is actually one of our largest categories. That includes the right to attend school, as well as discipline in the school setting and access and proper accommodations under special education needs. We do have family in there, and family does have quite a high number, but a lot of those calls do come in from parents or young people who want the OCL appointed. So we talk to them a little bit about the process and how to have that done, as well as sometimes we talk to them before the OCL has been appointed because they're waiting for that process to take place. But that's the work we don't overlap with the work of the Office of the Children's Lawyer. So we just kind of help them along to understand how they can ask for the Office of the Children's Lawyer to be involved in those circumstances. Immigration refugee, those are mostly the CASA clients. So that's the Childhood Arrivals Program I talked about. So it's young people who don't have immigration status. And then the leaving home is a funny category for us because it involves lots of things. It involves going to school. It involves finding a new housing situations, income maintenance, etc. But we cluster it together as leaving home because that's how it presents itself when a young person calls us. So before I go into the youth justice content, I just want to check in if there's any questions about the front end, about getting a lawyer, legal aid, or legal clinics, if there's anything specific that anyone has about that. Okay. I'm not hearing anything. So sorry, Teresa, is something coming up? Oh, okay.
No, I was just gonna say you can ask your question in the chat, and then we'll read it out for you, or you can go ahead and raise your hand if you have a question that you wanted to ask Emily.
Okay, perfect. So thanks for monitoring the chat because I can't really see it while I'm sharing my screen. So I will continue on with the youth justice piece. So we have a guide. It has 11 chapters to it, and these are the different chapters. And so that's on our website. And so I want you to know that there's lots of content that we're not going to discuss today because I'm just skimming over the basics. Introduction, the court process, and the records are the ones I'm going to focus on. So this is what it's going to look like on our website. I said there's a lot of information on our website. This is what the youth criminal justice section looks like. So if you look on the left, it'll be a Q&A format. And if you look on the right, it's all those categories. And if you look at the list where it says the police, bail, right to a lawyer, that column on the right-hand side, that actually corresponds with the publication that I mentioned on the slide previously. So these chapters are also going to reappear in this format. And that's how we provide the information on our website. So YCJ Basics is the ages applies is 12 to 17 years of age. So someone who's under the age of 12 cannot be charged. It doesn't mean that there won't be police or child welfare involvement if a crime is committed, but that young person can't be charged. That child is not eligible to be charged unless the activity occurred after they turned 12. And 17 is the end as well for when the Youth Criminal Justice Act applies. Once it's past that age, if the alleged crime occurred after the age of 18, then it's into the adult criminal system. So the benefits of being in the youth criminal justice system is that youth are presumed to have less culpability. They have a lot of vulnerabilities. They're still maturing, and that in the younger years, you have a higher success rate for rehabilitation. So that's kind of the goal. So the idea is not punishment. The focus is going to be rehabilitation. They also recognize that, you know, labeling someone as a criminal is also antithetical to being rehabilitated and reintegrated in society. So that's kind of the goal of the YCJA. And the process of going through the court systems, there's some little bit different in the youth system than the adult system, but the laws that apply, like what is a crime, it's all in the Criminal Code of Canada. There's no separate laws for youth. It's all the same for adults and for youth. What happens is we're going to talk a little bit about the youth records. The other thing that is a little bit different is some of the court processes, which we'll talk about. There's also enhanced protections, and that's the privacy rights. So if you listen to the news when they talk about, you hear that, several young people have been charged under the Youth Criminal Justice Act. We can't name their names. These are the crimes. So they can list, the media can report on kind of on the broad scale of what's happened and things like that, but they can't use any information that might identify who those young people are directly. The other big thing under this, we're talking about rehabilitation, reintegration, is that the concept of general deterrence does not apply. So the difference, there's general deterrence and specific deterrence. Under general deterrence, what that means is that we're going to punish you so no one else will commit this crime. And then general specific deterrence is we're going to punish you so you don't commit this crime again. So under the YCJA, the focus is the specific deterrence. It's about what will deter that young person from committing the crime again, not what every young person, how it'll deter young people as a whole, because the assumption is that, the young people they're not aware of the crimes necessarily. They're not aware of the sentences and what happens. So those are kind of the differences that occur. The other big difference that occurs is if any of us are stopped by the police, we have a right to remain silent. We have a right to a lawyer. The one thing that's different for a young person, that's an additional right, is that they can ask to have an adult with them that they trust. It doesn't have to be a parent, but they can have an adult with them that they trust when they're being questioned by the police. And that's an extra right that young people have that the rest of us as adults do not have. Okay, quickly. So this is kind of a guide on the flow chart and how things go through the court system. We have a start at the top and an end at the bottom, but the processes are not always straightforward. Creating a chart like this was quite difficult because what happens is not always, you don't go from 1 to 2 to 3 to 4 and then it's over. So when I say here, so there's the arrest, so that is once, but the bail hearing can be more than once. There can be multiple bail hearings. There can be bail variations. There could be being released and then brought back because of a breach or some other concern, or the surety no longer wants to be the surety, and then there'll be another bail hearing again. So saying that there's like a bail hearing is not totally correct, but we list it that way. The other thing that occurs is what we call set date. You go to court, and there's usually multiples of those. So usually you have to go to court a number of times to wait for your disclosure, and sometimes things may be changed, like your conditions or things like that during those set dates. But as a whole, most people have multiple set dates before anything happens. In that process as well, what we have on is EJS. So EJS is extrajudicial sanctions. It's diversion. So that's the term that they use for it, EJS. So that's something to remember and flag because that's what you'll hear. But it is diversion out of the justice system. So those usually, if there's going to be a diversion, it usually happens at one of those set dates. So the young person agrees to diversion, and then they meet with probation to try and work it out. And usually most courts give that young person 6 months to complete their diversion provisions. And then there will be another set date appearance where if they've completed everything, the charges will be withdrawn and they're gone. If that doesn't happen, if there is no diversion, things aren't being agreed upon, then there is what we call a Crown meeting, and that's the defense counsel meeting with the Crown lawyer, the government lawyer, to see if there's something that can be determined, agreed upon, and also to sometimes as well on top of that, later on it's a JPT, so judicial pretrial. So the judge is involved, and that is usually the point where it's talking about, okay, if we're going to go to trial, how long is it going to take? How much court time do we need to book? And working out all those details is kind of what happens. And the reason that middle category has those little circles around it is because there can be many of them before anything goes down to the third level. And at the third level there's either a guilty plea or a trial, and there could be a finding of guilt. That's on one side. The other side is there's a trial and the person's found not guilty. And when they're found not guilty, that is the end of it, unless there's been an appeal. So that also happens. Appeal process get complicated and makes things last a lot longer. But if the person is found guilty, they also get the opportunity to appeal. And if they're found not guilty, the Crown attorneys also have a chance to appeal. So it's a long process. In the youth system, it's supposed to be a lot faster, so it's not fast, but things are supposed to proceed a lot faster than they do in the adult system. So if, for example, someone had a 5-day trial that they had to have, for a young person, it would probably be booked within the year. For an adult, it might happen in 2 years. So that's just like a little bit of an example of how elongated sometimes the processes take in the adult system versus the youth system. We have 2 booklets, Youth Criminal Court Process and Bail and Youth Court as well on our website, and they're all in those same categories, the bail section and the court, attending court process. Records. So that's the big Q. Lots of people have questions about that, so I'm going to spend the bulk of the rest of this time that we have before the Q&A on this piece about the records. So youth records are not sealed at 18 years of age. So that's a misconception, and sometimes lawyers get it wrong, sometimes the police get it wrong, and the young person believes that, oh, my record should be done by now. Or they think that their records are done like as soon as they finish their sentence, and that's not true either. So it's very specific in the Youth Criminal Justice Act when things end, and it depends on the outcome. So if that young person took EJS, the diversion that we talked about a moment ago, then they're waiting 2 years after they've agreed to the sanction before their youth record is sealed. If they're found not guilty, then there's 2 months after the deadline for an appeal passes. If there's an appeal, then it's a longer wait time. So, what's built into the system is a bit of reasonableness, where 2 months after the deadline provides time for everyone to seal those records. So administratively, you can't, just to make sure there's no errors and that the young person understands that there's going to be a bit of a wait period, and to be careful about what might happen in that wait period while it's still on the record somewhere. If the charges are dismissed or withdrawn, same thing. It's 2 months. So found not guilty, withdrawn, dismissed. The other thing that judges can do is they can give a reprimand. So it's from the judge reprimanding the young person for their actions, but that is the end of the sentence. So there is no ongoing time frame. So that's the 2-month wait period in that circumstance as well. So then there's other thing that people have heard of is charges can get stayed. So the charges have been stayed by the court. They're not likely to come back up again. And so nothing's going to proceed. So it's going to take 1 year for that record to be sealed from that day. And then discharges are, if you complete these, you are being found guilty, but if you complete it, we're going to give you an absolute discharge. And then if it's an absolute discharge, it's only a 1-year wait. If it's a conditional discharge, it's a 3-year wait. So these are very specific and very detailed. So it does depend on what's happening. Depends on, when somebody asks about it, we want to get more details, get more information. But the bulk of young people who call us and have big questions is they have been found guilty. So they've been found guilty. They either went to trial or they pled guilty. And now what? Now how long do they have to wait? So this is the big one. They have to wait 3 years or 5 years from the end of the sentence. So from the time they finish the sentence is their wait period begins. So that's often well beyond the age of 18. So I'll give you an example. If a 16-year-old has been charged, they have a trial, and at 17 and a half, they're sentenced to 2 years. It could involve some jail time, it could involve some probation time, it could involve a bunch of things, but 2 years is the sentence. So that means they won't be done until they're 19 and a half, because I use 16 and a year and a half to go through the court system. So if it's 19 and a half years, if it was a less serious offense, they have to wait 3 years from then. And if it's a more serious offense, they have to wait 5 years from then. So they're well beyond the age of 18, which means they're into like their adult lives. And they have this youth record that's still there. And so once it's sealed, it is sealed and it can't be used again up against them again. But if they do commit a crime before it's sealed in their adult lives, then it actually becomes part of their adult record and isn't sealed in that way anymore. It becomes part of the adult system. And then there's other provisions, but it's not sealed. It's not gone forever, kind of gone, which is how the youth records work. They can't, so it also means records can't be given to anyone else. Anyone who knows about them can't tell anyone else. The police records have to physically be destroyed, including any DNA that they, records that were there. Other records can be either destroyed or permanently sealed and no one else can see them. A young person can ask a judge to see their own records, but it can't be used against them for doing that. And it doesn't necessarily let them share it with anyone else, but they can ask to see it for themselves. Sometimes this happens because young people don't remember what happened because it was so long ago. And so sometimes they go back and ask for some information. It's not that common, especially if they had a lawyer, then the lawyer would also have those records. And we have different provisions on when, like, we can never reveal those records, but we have also provisions through our law society on how long records are kept as well. So I already talked about this, but I put it in the slide so everyone would have it. So adults, this is the adult system, how it's a little bit different. So I keep using the language found guilty for a young person. So in youth court, a young person is found guilty. In adult court, they're convicted. So that's why I'm using that language. So if found guilty and given an adult sentence or after turning 18, it's a conviction. So there are circumstances where a young person who's under 18 at the time the crime occurred is found guilty, and then the judge orders an adult sentence. They stay in the youth court system until that process happens. But if it's an adult sentence, then it's deemed a conviction and is part of the adult criminal system. And for adults, they have to get what's called a record suspension. It used to be called pardons. They've renamed it. It's called record suspension. And a record suspension also has the similar wait time periods for when you can apply for it. The big difference with a record suspension is that once the record suspension is given, it can be taken away. So if the adult commits another crime, the record suspension, the whole adult criminal record is back. Anything that was in the youth record alone and that was sealed, that cannot come back. So that's the big difference between something that's a youth record that gets sealed and an adult record suspension process where it's not as permanent if they don't remain of good behavior. There are some exceptions, serious offenses, serious violent offenses, and offenses of a sexual nature. So those are very specific, and we always tell someone if you've been found in these circumstances, you should talk to your lawyer about the specific circumstances. And if it's a while ago and you can't contact your lawyer, then you can call our office and we can try and help figure it out with that person on whether or not their records have been sealed or not. For working, which is a big one, so employment questions that come up on most forms and most documents is, do you have a criminal record? And have you ever been convicted of a criminal offense? So youth get a youth record. They don't actually get what's called a criminal record. So if it's a youth record, it can honestly say no. And youth are found guilty. So they can honestly also say no, they've never been convicted of a criminal offense. It's a language thing. The government did put that in place. It was done purposefully. And so the young people are not lying in these circumstances. Youth record and found guilty, it means they don't have a criminal record and they have not been convicted of a criminal offense. So those are the employment questions. There's background checks that occur. So background checks that occur, they should always go to the person themselves, and then they'll see what's there. There's different kinds of background checks, and so depending on what kind of background check, it's going to show different things. So the one that I flag most people is the vulnerable sectors background check, and that is working with people that are vulnerable. So it could be involving children or the elderly or people with mental health needs. And so in those circumstances, if the crimes are of a serious nature, sexual nature, and it was against a vulnerable person, then that might flag different things in that check system. But ultimately the record goes to the young person and they can see it and they'll know what's happening before they go ahead, and they can always call us and talk about it, and what to do at that point. So some of the concerns are, I said that the young person can say no to not being convicted, but sometimes they ask anyways, and sometimes in those record checks, there's something in those records check that come up, and so then they have to make some decision on whether or not to provide it if the employer asks for it, and that's when we say you should really talk to us and we can talk through your circumstances and what can be done. Sometimes what we do say to some people, depending on what it is, do you have other good references? Are there adults in the community that can vouch for you, write you letters of support? That would get you a long way in an application. So for schools, the biggest concern that people have is for college and university. And so for colleges and universities, sometimes they ask for a vulnerable sector check in advance of at the same time you apply to the program. And the reason they're doing it is because lots of them have placements. So teachers, social work programs, nursing programs, you have placements in those settings, and you can't be placed there if you can't pass a vulnerable sectors check. So some schools can require it. So that's something to know. Travel is different depending on where you're traveling to. Every country has their own laws about who can travel. They ask different questions about whether or not you've committed crimes and things like that. So that's something to know about. The biggest one for us in Canada is the Canada-US border. We have agreements in place where they can check the background check for everyone who's trying to cross the border. For a young person specifically, youth records do not show up. So that's something to know. They don't show up when the US Customs pulls it up, but there's other things that they can ask. They can ask things because they're not bound by the same rules. So they don't have to ask what the employers ask, right? The employers ask about criminal records, the employers ask about convictions. Border officials can ask different things. They can ask, have you ever been charged with a crime? Which is very different, right? Even you could be charged for a crime and found not guilty. You could be charged with a crime and it's dropped, or the records could be sealed, or you have a record suspension, or et cetera, et cetera. But ultimately, the question itself is, did that charge happen? So there are other things they can ask. So the thing to know is, be very careful how you answer those questions, because lying to customs officials can also be another reason that you're turned away. And being turned away and sent back is one thing, but being turned away and banned from returning is something else that also occurs. Doesn't always occur, sorry, that can also occur. So that's something to keep in mind. I do know people who've been banned to travel to the US, and there is a waiver system in place. It's quite expensive and it's a short term, I think it's 2 or 3 years you get a waiver. There's a whole process, and you can go on the US government website and try and figure that out. It should be there, some of that information on how to apply for that waiver if you've been banned from entry. Okay, so the youth record, again, so it charges like outstanding charges, findings of guilt, absolute or conditional discharges, any conditions like probation terms, and arrest warrants. Those are the ones that's before sealed. That's what's there. Once it's been sealed, then those aren't there anymore. The adult record, again, is a little bit different. It's about convictions, not automatically sealed, can get the record suspension, but the record suspension you can lose if you're charged again in the future. Access and privacy. I'm not going to go through all this list because I've provided it to you and I want to have time for some Q&A before I get through the end of my slides. But there's general rules about who can see the records and there's privacy rules, and that's all to protect the identity of that young person. Access, even if that group of people have access, it doesn't mean they can further disclose it. So just because you have a right to see that information, so this is the list on general rules of who has access, just because you happen to be one of those people, it doesn't mean that you can further tell other people about it, right? So so privacy is really critical to the youth criminal justice system. Permitted disclosures, it has to be necessary and limited information. So this is what comes up a little bit in the school system, is that in the school system, if that young person was charged, say a young person was charged with assaulting another young person, and now they have this condition to stay away from each other, right? So sometimes the school can know about that because they want to make sure that they don't put them in the same classes, or they might move them to a different school because of these conditions. So there's different things, but it should be quite limited and restricted to who needs to know. The other way to find out about, the other way some people try to find out information and to disclose, to get access, is sometimes the media asks for information. And so that's happened in the past where the media sought like all the statements that were entered in court. They claimed it was because they wanted copies of the statements because they want to report on it properly. They don't usually win in the youth cases. It has to be quite serious for them to be getting it, and so that's generally what's happening there, because they're allowed to attend in the courtroom and they're allowed to take notes, and so and as long as they don't identify the people involved, so it's not likely that they'll get physical copies of court documents. There's been other cases as well where sometimes landlords go and ask for copies, or they want to sue the young person because there's damage to property and they want money to compensate for that. So they'll have to go to court and ask for access to those records. And those, when that happens, should definitely speak to a lawyer about protecting as much of the record as possible. Okay, I've sped talk for a long time. I'm at the end. This is our poster. That's our contact information. We have a website. Again, we're on Twitter. We have a YouTube with some videos. All of those are linked within our website. So I'm going to close this conversation here so we can move to some Q&A.